Hi again, Risa here, back with another episode of Ask Risa. This is my weekly video series where I answer some common wedding planning questions and give you advice on problems that you might be having in trying to plan your wedding. This is episode 27. There are a bunch of other episodes, and you can find all those on my YouTube channel, which is under Risa James Events. They're all grouped together in a playlist, and they're all titled Ask Risa episode whatever. So there's lots of information available to you in previous episodes. This week I want to talk about something that's not super fun, and it is how to fire a wedding vendor if you are having a problem with them. This is something that comes up not often, but surprisingly, more often than it should. I have had clients in the past who've had trouble with their venue, their caterer, their band, their rental company, and almost every time it's the same problem. It's non-responsiveness. The vendors aren't getting back to them and they're not communicating to them. They're not responding to emails or voicemails or texts or anything like that. And so communication is really important. I mean, your wedding is obviously a very important day. You're spending a lot of money. There's a lot on the line and you want to make sure that it's perfect. So communication is key. And it can be frustrating and concerning when you're trying to reach one of your vendors and they're not getting back to you. So if you get to the point where you feel like you need to fire the vendor, here's a little bit of advice. First, don't wait and let problems escalate or fester. If you're having trouble reaching a vendor, don't just hope for the best and think, oh, well, they'll get better later. Try to resolve the problem as soon as it starts happening. If you're trying a certain communication avenue and it's not working, try a different one. So if you're emailing them, try calling them. As stupid as this sounds, there are wedding vendors who do not do well with email. Some of them just don't do well with technology. Some people, despite the fact that they own their own business, are not great writers, and so they have a hard time communicating in written form, and they do better verbally over the phone. Even though I know millennials hate using the phone, would much rather email it. I also am a fan of email, partially because there's a paper trail and you can go back and see what was said. Also because you don't have to respond to something right there in the moment. If someone calls you, it's kind of an interruption of your day, but if they email you, you can email them back when it works for you. But if you're having trouble, try a different avenue and maybe you'll have some better luck getting a hold of them. If you literally just cannot get a hold of these people, they've like fallen off the face of the earth, then you probably don't have much other recourse other than finding someone else, which can be tricky depending on a couple of things. So basically it depends on whether you have a contract and whether you paid them any money. So if you haven't paid any money to this person, and you don't have a contract with them, then you have no problem. You can just send one final email or text or whatever and just say, look, this isn't working, you're not responding to me, I'm gonna go a different direction, best of luck. And you wash your hands of the whole situation. That's the easiest approach. This is unlikely, but if you signed a contract but you didn't pay a deposit to them, then you should read the contract. I mean, you should have read it when you signed it. Hopefully you did, but you probably didn't because most people don't. So look at the contract and see what it says about termination, because a contract spells out your obligations and it spells out the vendor's obligations. Maybe there's a clause in there about communication. There probably isn't. Most contracts don't include that. It's not a very standard clause. But if you can get out of the contract without any sort of monetary penalty and you haven't paid any deposit, then again, just let them know, look, this isn't working out. You're not responding to my emails. I need someone who's more cooperative. I'm going to go a different direction. It gets really tricky when you've paid money. Most of your big wedding vendors, like planners, caterers, DJs, photographers, venues, they're going to require a deposit from you when you book them. And that is because most of us can't do more than one wedding in a day. So as soon as you book with us, we are going to take that calendar out of our availability, like that date out of our availability. We're going to block it off on our calendar. And if somebody else inquires for that date, we're going to say, no, I'm sorry, I'm already booked. We're going to turn away business because we're reserved for you. So if you decide to cancel your wedding or something happens and you want to move the date or whatever, most of us, I know I do, have clauses in our contracts that say that deposit is non-refundable. In my particular case, I will apply the deposit to a rescheduled date if I'm available, but you don't get your money back because I have reserved that date for you and I have turned away other business. And so that deposit is compensation to me for you basically pulling the rug out from under me. So most deposits are going to be non-refundable, unless you can show that the vendor breached the contract. So breach of contract just means that they didn't live up to one of the obligations they agreed to in the contract. Again, like I just said, obligations are spelled out in the contract. Obligations for you, obligations for the vendor. And if one of you doesn't live up to what your obligations are, then you're considered to be in breach of contract. And so when the contract is breached, then those obligations go away. And if you can show that a vendor breached the contract, then you might be able to get your deposit back, but you're probably going to need an attorney to help you. You're either going to need an attorney to write a letter on your behalf, or you're going to need to sue them to get your deposit back. In California, you can sue in small claims court for amounts under $10,000. You don't need an attorney to go to small claims court. You can represent yourself, but you still might want to have an attorney just because even small claims court can be challenging and can be complicated. But so this is definitely only an avenue that you want to go down if it's pretty serious. If you haven't paid the vendor that much money, it might be better to just let it go. Just take it as a loss. If you really need to get away from that vendor and it's only a couple $100, maybe you just forget about it and you find a different vendor and you move on with your life. Because, hiring a lawyer, they're not cheap. It's going to cost you some money. Even just hiring somebody to send a letter could cost you more to pay the lawyer to send the letter than you actually paid in deposit that you're trying to get back. So it's a real cost benefit analysis that you have to go through to figure out what you want to do. But if you can, trying to resolve the conflict without resorting to suing people or threatening people is always preferable. And it could be just a situation that is, with the caterer, the client I had who had trouble getting a hold of her caterer, it was basically just a situation where the wedding was a few months away and the caterer's excuse was that she doesn't really start paying attention until 2 months out. That's a super lame excuse. Like, that's not acceptable customer service, but she wasn't being malicious about it. And in the end, everything was fine. As we got closer to the wedding, she did get more responsive. With the venue problem that I had, that was a whole different can of worms. We ended up staying with the venue. It had changed management in the course of the planning of the wedding. But in the end, it also turned out. Most times, these things will work out if you just try to resolve it. Very rarely have my clients actually had to change vendors. And in the few cases that it's happened, it's been a situation where there was no deposit at stake. So it was easy because they hadn't paid any money yet. And so it was easy just to walk away. But it's all about your specific situation. And so this video isn't legal advice. I'm not telling you legally what to do, but if you have a specific situation and you feel like you need legal advice, certainly seek that out. Find an attorney who specializes in contract law, and they can evaluate your particular contract in your particular situation and let you know what your options are. But generally speaking, your best bet is to try to work it out with the vendor because that's just going to be the easiest for everybody. So if you have any questions, feel free to let me know in the comments. And if you found this video helpful, I would love it if you gave it a thumbs up because that helps other people find it. Maybe they're having a problem with their contracts too. You never know. Everybody's got similar problems out there. So I will be back next week to talk about something more fun than breach of contract. I promise. All right. Have a good week.